A pleasant day to you, ma'am. I am Jovel P. Sagusay from BCHM 3B, and this is my chapter 3 entitled Law on Obligation and Contrast. So according to Don Shirley, Colorado in Technical University, the ethical basis of business is integrity, an ethical aspect that unites both private morality and public and professional ethics. So before we proceed to the topic, here's are the learning objective. The students are able to identify the different kinds of obligation and contracts, to be able to enumerate the ways of extinguishing an obligation, and third is to be able to enumerate possible application of contracts in tourism, travel, and hospitality industry. Next is the topic outline. So, a person desiring to engage in a business in the tourism, travel, and hospitality industry will meet certain obligations. Agreements arising from contracts will have to be made, and potential branches from their agreement will be encountered. Therefore, there is a need to study to fundamental principles involving law on obligation and contracts. So first, the obligation. In Article 1156, an obligation is a juridical necessity to give, to do, or to not to do. Here's the discussion of law. So an obligation is a legal duty, however created, the violation of which may become the basis of an action of law. Every obligation has four definite elements without which no obligation can exist to it. So first, obligation or first element is that an active subject, also known as the obligee or creditor, who has the power to demand the prestation. Second, a passive subject, also known as the debtor, who is bounded to perform the prestation. Third, an object of the prestation, which is the object or undertaking to give, to do, or not to do. And lastly, the juridical or legal tie, the vinculum which bind the contracting parties. The juridical tie or vinculum is a base of the sources of obligation arising from either the law or contract. It is important to identify the prestation is a certain obligation. Once the prestation is identified, you can determine who passive subject is, who the active subject can demand fulfillment of the obligation. The sources of liability for damage of property in obligation are the following. First is fraud. The fraud is incidental fraud, which is a fraud incident to the performance of an obligation. In fraud, there is an intent to evade the normal fulfillment of the obligation and to cause damage. Second, negligence. So a negligence referred here is the case of contracts. Is culpa contractual, the lack of diligence or carelessness. Negligence consists in the omission of the diligence which is required by the nature of the obligation and correspond when the circumstances of the person or the time and of the place. Third, delay or mora. The debtor can be held liable for the delay of default in the fulfillment of the obligation only after the creditor has made a demand, judicial or intrajudicial on the debtor, except when the law precisely provides demand is not necessary. Second is when time is of the essence. Next is when the contract expressly stipulate that demand is not necessarily. And lastly, when the demand would be useless. Fourth, the contravention. The contravention of the tenor of the obligation. Performance is in contravention of the tenor of terms of what the obligation means, where the performance is contrary to what is agreed upon on stipulated, thus making the debtor liable for damages. So according to Article 1157, obligation arise from first law, Second, contrast. Third, quasi-contracts. Fourth, act of omission, punishment by law. And lastly, quasi-delects. Source of obligation. First is law. When they are imposed by a law itself, for example, obligation to pay taxes, obligation to support one family, and second is contracts. When they arise from the stipulation of the parties, a contract is a meeting of the minds between two persons, whereby one bind himself with respect to the other to give something or to render some service. For example, the obligation to pay a loan or indebtedness by virtue of an agreement. Next, quasi-contract. Quasi-contract when they arise from the lawful, voluntary, and unilateral act which are enforceable to the end that no one shall be unjustly enriched of benefited of an expense of another. For example, the obligation to return money paid by mistake or which is not due. There are two common forms of quasi-contracts. First is the solutio indebiti, which is payment by mistake, and second is negotium gestu, which take place when a person without the consent of the owner assume the management of an abandoned business. Next is crime or act and omission, punishment by law. So the consequences of the criminal offense when they arise from accessibility, which is a consequence of a criminal offense. For example, the obligation of the thief to return the car stolen by him, the duty of a killer to indemnify the hair of his victim. And lastly, the quasi-delects or torts, when they arise from a damage caused to another through an act or omission, there is a fault of negligence, but no contractual relationship exists between the parties. For example, the obligation of the head of the family that lives in a building or apart, therefore, to answer for damages caused by things thrown or falling from the same. So the obligation of the possessor of the animal to pay the damages which may have caused. So next is the classification of obligation. So there are 6 primary classifications of obligation under the Civil Code. So first is pure and conditional obligation or Article 1179 to 1192. Second, obligation with a period or Articles 1193 or 1198. Third, alternative or the Article 119 to 1205 and the facultative obligation or Article 1206. Fourth, join the solidary obligation or the Article 1207 to 1222. Fifth is the divisible and indivisible obligation or the Article 1223 to 1225 and lastly, the obligation with a penal clause or the Article 1126 to 1130. Next there are 4 secondary classification of obligation under the Civil Code. So first, secondary obligation is the unilateral and bilateral obligation or the Article 1169 to 1191. Second, real and personal obligation or the Articles 1163 to 1168 and the civil and natural obligation or the Article 1423 and lastly the legal, conventional and penal obligation or the Article 1157 to 1159 and 1161. Next, mode of extinguishing obligation. So the Article 1231 or the obligation are extinguishing by payment or performance, by the loss of the things due, by the condonation of the remission of the debt, by the confusion of merger of the right of the creditor and debtor, by compensation, and lastly by novation. So, other causes of the extinguishment of obligations such as annulment, rescission, fulfillment, or resolution or resolutory rather condition, and the perception and the govern elsewhere is this Code 1156. Next, contracts. In Article 1305, a contract is a meeting of mind between two persons whereby one binds himself with respect to the another, to give something or to render some service, or 1254. Here's our discussion of law. So a contract of adhesion is defined as one in which almost all the provisions have been drafted only by one party, usually a corporation or insurance company. The only participation of the other party is the signing of his signature of his adhesion. So some writers believe that some of the contract suppresses the will of one of the contracting parties, hence not a true contract. However, this is not always juridical true. Normally, the party who adheres to its unreality free to reject entirely. If he adhere, then he give his consent. Next, characteristic of a contract. So first, mutuality of contracts. Mutuality of contract, its validity and performance cannot be left to the will of only one of the parties. Second, autonomy of contracts. Autonomy of contracts, parties are free to stipulate terms and provision in the contracts as long as these terms and provision are not contrary to law, moral, good customs, public order, and public policy. Third is relativity of contracts. Contracts are binded only upon the parties and their successors. In interest, exception, stipulation in favor of the third person, stipulation for a third and its beneficiary of an insurance policy. Fourth, consensuality of contract. Contracts are perfected by mere consent and no form and prescribed by law for their validity. Exception, a real contract such as pledge, chattel, mortgage, contract covered under the statute of fund. And 5 is the obligation force of contract. By the obligation force of contract, it constitutes the law as between the parties who are compelled to perform under the threat of being sued in the court of law. Next, the undertaking of the use of safety deposit box or the execute by Mr. McCullen intended with the nullity. In the Article 2003 of the Civil Code is controlling thus. In the Article 2003, the hotel keeper cannot free himself from responsibility by posting notice to the effect that he is not liable for an article brought by the guest. Any stipulation between the hotel keeper and the guest whereby the responsibility of the former as set forth in Article 1998 to 2001 is a surprise of diminish shall be void. In the Article 2003 was incorporated in the new Civil Code as an expression of public policy precisely to apply to situations such as the presented in this case. So the hotel business is like the common carrier business is imbued by the public interest. Catering to the public, hotel keeper are bound to provide not only lodging for the hotel guests and security to their person and belongings. So the twin duty constitute the essence of the business. So the law in turn does not allow such as duty to negated of diluted by any contrary stipulation, so-called undertaking the ordinarily appear in prepared form imposed by hotel keeper on guests to their signature. Here's are the classification of contracts. First, according to their relations to other contracts. Under this is the preparatory of those which have to their object an establishment of a condition in law which is necessary as the preliminary step toward the celebration of another subsequent contract. For example, partnership, agency, common carrier, and insurance. Next is the principle of those which can subsist independently from other contract and whose purpose can be fulfilled by themselves. For example, sales, lease, a common carrier and insurance. Next is a accessory of those which can exist only on the consequence of on in relation with another prior contract. For example, pledge or mortgage. Second is according to their perfection. Under this is a conciliator, those which are perfected by the merge agreement of the parties. For example, sales and lease. Under this, second is real of those which is real not only the consent of the parties for their perfection, but also the delivery of the object by one party to another. For example, commoditum, deposit, and pledge. Third, according to their form. Under this is common or informal, so those which is required a particular form. For example, loan. Second is special or formal, or those which require some particular form. For example, donation, chattel, or mortgage. Fourth, according to their purpose. Under this, transfer of ownership, example, sale, conveyance of use, example, commoditum, rendition of services, example, agencies, lease, and service labor. Fifth, according to their subject matter, like things, example, sales, deposit, and pledge, services, for example, agency, lease of service labor, and sixth, according to their nature of the vehicle which they produced, like unilateral or those which give rise to an obligation for only one of the parties. For example, commoditum, gratuitous deposit, and bilateral or those which give rise to a reciprocal obligation for both parties. For example, sales and lease. 7 is according to their cost. Under this is one runs or those in which each of the parties aspired to procure for himself a benefit through a given of the equivalent or compensation. For example, sales, insurance, common carriers, gratuitous of those in which one of the parties proposed to give the other a benefit without any equivalent or compensation. For example, commoditum. 8 is according to the risk involved. Under this is the commodities, or those where each of the parties acquired equivalent or his prestation, and such equivalent is pecuniarily appreciable and already determined from the moment of the celebration of the contract. For example, list. Next is the alctari, or those where each of the parties has to his account an acquisition of the equivalent of his prestation, but such equivalent, although pecuniarily appreciable, is not yet determined at the moment of the celebration of the contracts, since it depends upon the happening of uncertain events, thus charging the parties with the risk of loss or gain. For example of this is the insurance. Next is denominate of those which lack individuality and are not regulated by special provision of law. In the Roman law, the innominate contracts were classified into 4 groups. First, I give and you give. I give and you do. I do, you do, and do what you do. And that's all about my chapter 3. Thank you.